In our top story this half hour, the Supreme Court of Appeals in Bloemfontein has reserved judgment in the sentence appeal case against Oscar Pistorius. The National Prosecuting Authority brought the case to appeal the 6-year sentence Pistorius received for killing his girlfriend Reeva in 2013.
The Supreme Court of Appeals heard arguments against and for the extension of Oscar Pistorius' 6-year jail term. The NPA argued that Pistorius showed no remorse and Judge Masipa failed to give substantial and compelling reasons for the 6-year sentence.
And so we say that in terms of the law, in terms of the Act, the quota quo ought to have started, first listed the substantial and compelling factors, then said, because of their presence, I now deviate from the minimum sentences. In deviating, I then say that these are some of the mitigating factors that will allow me to lessen the sentence from 15, taking into account his time in incarceration. Tongue-in-cheek, I say, maybe she could have said, probably we're at 13, but the court does not have a clean slate. The quota quo does not have a clean slate from which he departs.
Defense lawyer advocate Barry Rue argued for Oscar's reasoning to fire repeatedly as he believed there was an intruder in his house. He also stated that it was unfair to say he did not show any remorse.
The submission that I make, for purposes of sentence, he's been convicted. That's what it is. But for purpose of sentence, we cannot isolate. And the 4 shots are wrong. The 4 shots are wrong. But it cannot be isolated from the circumstances surrounding that. Who that person was and what circumstances at 3 o'clock in the morning.
The National Prosecuting Authority says they are confident the judges will be balanced in their ruling.
We've got abundance of talent in the NPA. We've shown today we got a black female to lead the arguments and lead the prosecution team in the SCA. She did exceptionally well. We are highly optimistic that the court would grant the leave to appeal and rule in our favor.
Reeva's mother attended the appeal surrounded with family and friends who say they will never have closure.
The Steenkamp family, their whole attitude is and has been from the start. They absolutely believe in the justice system. They support the justice system. They will never have closure because they've lost their daughter. That's the way they feel. That's why they focus everything on the Reeva Rebecca Steenkamp Foundation, which is a foundation that they established in Reeva's name to continue the work that she started.
After half a day of arguments, the matter has been set down with the judgment reserved. With Giovanni Machane, ANN7, Bloemfontein.
Joining us in studio, Advocate Maile Ngake, Transform RSA lawyer, and Kabelo Siabi, an attorney or lawyer who joins us live on the phone. Siabulela Gentile, hashtag Naughty in My Name SA, Chief Executive Officer and co-founder. And good evening to all our guests, and thanks so much for joining us. Let's start with you, Ngake. In terms of the precedence that has been set, whether there had been an extension of a sentence once conviction has been laid and also sentencing been handed down.
Look, it's my view that it's quite unprecedented for them to do the extension of sentencing, particularly that in the initial appeal, there has been a view that they refer the matter back to the initial judge for sentencing, and they have since pronounced herself in this respect. And one will wonder whether the current demand or the current interest by the National Prosecuting Authority for the fact that subsequently they need an extension of sentence can fly. But indeed, given the fact that the conviction is now of murder and there's minimum sentence in respect of murder, I'm looking forward to see whether they will indeed pronounce. And that would be quite a precedented case since the new dispensation and constitutional democracy in the country. Looking forward for the ventilation thereof and the subsequent decision by the judges. Yeah,
because the NPA, Mr. Siabi, is arguing that the defendant, or rather the convicted murderer, Oscar Pistorius, hasn't shown remorse. I mean, under which circumstances or what is it that needs to satisfy the court that indeed, or rather the prosecution, that he has shown adequate remorse? Siabi, we'll get back to you. Maybe you can respond to that, Ngake.
Look, the issue of remorse, it's whether it has been sufficiently evidenced by the nature. And my observation has been that the fact that he apologized is not enough. And if then that is the case, it's a good reason for them to look into minimum sentencing. And indeed, it's a good reason for any person who has been involved in such a heinous crime to find the ultimate decision of the courts.
Yeah, would the show of remorse or the expression of remorse also entail disclosing the truth and nothing but the truth to its finest detail? And in your view, is this what the defense was able to portray in court?
Look, this is one case that was quite complex, Cindy, in the sense that the evidence adjudicated come a long way. But critical to the evidence rule is to determine whether indeed it was adduced during the evidence, that there is no repetitive, what we normally call duplication of sentencing. But in dealing with duplication of sentence, it will be determined by the extent of evidence that was adduced, whether the fact that there was an indication of remorse, which most in this case there's not been very clear, because save that there's been an apologetic statement made, it would be determined by the judges whether that is sufficient to determine the remorse. But of course, the laws of this country make provision for instances where a minimum sentence can be changed to a lesser sentence. And if the Supreme Court of Appeal is going to make determination for the first time to say they will then revoke to the minimum sentence, we're looking forward for that.
All right, Mr. Siabulela Gentile, not in my name, SA Chief Executive Officer and co-founder, joins us on the phone. Good evening to you and thanks so much for joining us. The expression of emotion and, of course, the tears, breaking down and expressing trauma. We heard from the psychologist during the court proceedings that Oscar Pistorius had, childhood traumatic experiences that could have led to his demeanor, in the sense that he feels fearful for his life and therefore shot 4 times. But what the court needed to satisfy today was around a showing remorse. So you're saying that kind of expression, the tears and that doesn't necessarily, is not adequate enough as a reflection of remorse?
Yes, thank you very much, Cindy. Good evening. On this instance, I would like to say really that I agree with the state. But of course, we have a competent judiciary system in South Africa, to which I believe that Judge Masipa exercised her judicial right on this case. But also, it is important that, to note that one of the cases that the state is raising, one of the elements is that, of course, the judge failed to put compelling and substantial factors to deviate from the minimum sentence, as we know it, to be 15 years. So it's a tough one, honestly. But when it comes to the issue of remorse, I wouldn't know honestly whether Oscar is remorseful or not. But on this one, I would have to go with the state to say that it is in my opinion also that the sentencing should be, of course, revised and, if possible, revoked to a higher sentence.
All right, so please stay on the line. We have a caller, Mr. Van Reenen in Cape Town. Good evening to you and thanks for calling.
Good evening, Cindy, and good evening to your guest. Cindy, I've got just one straight and forward opinion. This is not about Oscar's 6-year sentence. This was from the start, from the start, was it? Because Mr. Nell just wanted to show a black judge that she was wrong. It's to me all about his ego, and that's my view.
But Mr. Garinal is no longer there. He's since gone into private prosecution. Why would the NPA then continue necessarily, in questioning the leniency of the sentence?
He was there, so he started the process.
All right, so it's a process that needs to be completed. Thanks so much, Mr. Van Reenen. Could that be the case, in that, they have to essentially close the file on this matter because it was initiated fresh after the conviction was handed down?
Cindy, correct. I mean, under this circumstance, they wouldn't have left the matter unattended. Moreover, that the conviction has been amended to that of murder. And the next thing to look into whether the minimum sentence is the ideal way to go. And under the circumstances, I think the judge will have to look into that. But indeed, Cindy, the unfortunate aspect of it is whether they have been in a position to apply their mind in terms of the and the facts then, and which is something that I would not be in a position to ventilate then, currently. But my observation has been that one of the good reasons that they referred matter back to the initial judge for sentences was merely for the fact that most evidence led was before her, and she would be best placed to mete out a proper sentencing under the circumstances.
And I mean, the mitigating circumstances around why he should get a lenient sentence had to do about his natural needs, or, you know, physical limitations, etc. Over and above that, but the family's quest and call for justice was not met. Do you think that this is something that the court would have to consider going forward in whether the sentencing is extended or not?
Look, I think the court will consider that. Look, the fact that there is a standard set on murder cases is clear. But the fact that, and furthermore, there is a challenge in the sense that it arose from what we normally call as eventualis, and circumstance of which it's not far from considering aspects of culpable homicide under the circumstances. And it's a challenge that we find ourselves in assessing whether it's all once and for all about what is prescribed within the Criminal Procedure Act, that because of schedule, this is the minimum sentence, and therefore we must just comply. But it has never been the practice, because the court has got the powers to reconsider a minimum sentence under certain circumstances. And under this case, disability having been identified by then Judge Masipa in her capacity over this matter as a reason, it's quite interesting. And it's more about the facts that were there. And the facts is clear that there has been a case where it was properly proved, and the judge decided that it's now murder, and the minimum sentence of murder should be the one could be considered.
All right, let's take a caller. Miriam in Klerksdorp. Good evening to you, and thanks for holding. Your question or comment?
Just talking about Oscar, I followed this case, but I just say, good gracious, I don't know why am they going so on with Oscar. I mean, Judge Masipa is twice already. He's got his sentence, but I can't understand, why don't they leave the poor man that he go on? I mean, he did. We feel for Reeva's, we understand for Reeva's parents. I understand, but I mean, that night that he shot, that 4 shots, I mean, he was also on his nerves. I would also perhaps, if I had a gun, shot 4 shots. So I think they can leave him now, man.
All right, so Miriam sympathizing with Oscar, saying he's already been handed down his punishment. He should be left in peace. Mr. Gentile, your view to that? Hi, Siabulela.
Hello?
Yeah, your view that he's already been punished enough, he's been given his sentence, lost his lucrative career, reputation, and all of that. But we have to consider Reeva Steenkamp's family. Nonetheless, the caller saying, Miriam says he's served his punishment so far.
Look, I think if we have to look at it that way, on what is it that he lost or what, it's going to give us a problem, because there are millions of men who are behind bars, and I'm sure half of them would also claim that they are remorseful. Other thing that we need to remember, which is very much important, is that bottom line is that Oscar Pistorius killed a person here. And we also need, when we sympathize with him, we should also not overlook the fact that there is a family somewhere that is still mourning the loss of their daughter. So the bottom line is that he has killed, and all the laws of the Republic that are applicable, all the sentencing that is applicable to cases of murder should also be applicable to him, and that his case should not be an exception just because he is physically unable to do other things. That is my opinion. Thank you very much.
All right, thank you so much, Siabulala Gentile. Not in my name, SA CEO and co-founder Joseph in Welcome, and Craig in Cape Town. We come to you next. Hello, Joseph.
Hello, Cindy. How are you?
I'm good. How are you?
Good evening with your panel, there. Look, our jurisprudence allows and justice allows rehabilitation and redistribution. Oh, okay.
We can hear the TV in the background. Please switch that off or turn it down.
Yes. Like I was saying, our jurisprudence and justice system allows rehabilitation and retribution. Pertaining to retribution, the life of an innocent person had been taken. And there must be a strong message that must be sent to the public that justice is being done and such cases have been dealt with by the court.
All right.
But Pretoria was quite remorseful in court, crying and breaking down, vomiting and also. The guy is a broken man.
Joseph, your point taken, saying that justice and retribution, that in itself has been met. We'll ask our legal eagle, Mr. Ngake, to respond to that. We go to Craig in Cape Town. Good evening to you, Craig.
Hi, good evening, Cindy, and your viewers. Cindy, I'm very interested in how the Supreme Court of Appeal is basically going to overturn the sentence of Judge Masipa, because the jurisprudence does not suggest that the Supreme Court of Appeal has that sort of
jurisdiction.
Yeah, they can't pull the law to that end to further its own end. This is not a retribution on top of retribution. He's been sentenced. The state had the chance when they appealed the judgment. That was overturned. Now, where in that judgment have they even asked that the court must then set down the minimum sentence requirement? For a minimum sentence requirement, there is a particular, very strict rule, and I think my learned colleague sitting there would actually maybe take us through that principles.
Okay.
I don't think this is about the Oscar Pretorius matter, but I think it's a legal matter and it's extremely important for future cases. Thank you.
All right, Craig, much appreciated. Can the Supreme Court of Appeal overturn the judgment and conviction? We'll put that to our legal aid here. And Eddie in Midrand, good evening to you.
Yes, how are you?
I'm very well, thank you.
Fantastic.
What's your question or comment, Eddie?
I just feel that the justice system doesn't really continue on a normal scale. So,
Eddie, turn down your TV set. It's giving us feedback. Please and be brief.
I'll do that. I just feel that Oscar. I mean, I have two beautiful daughters, and both of them look like Reeva, and I feel that somebody who could kill one of my daughters gets 6 years. I don't feel that's justice. I think that guy needs to sit forever. I don't care who he is, whether it's Oscar Pretorius or whoever he is. And I just feel that I'm hoping that he gets the correct sentence. Because, thank you very much.
Point taken. Thanks so much for calling. And
thank you very much.
Let's just, I hope you are taking notes in terms of the jurisdiction of the Supreme Court of Appeal, whether they can overturn and in fact instruct for a lengthier sentence to be meted.
Indeed, in this case, you know, the complexity of this case, Cindy, is the fact that the very Supreme Court of Appeal have changed the previous conviction and subsequently referred the matter back for the sentencing. And clearly, despite the fact this matter is a matter for appeal, I think it lacked interest in terms of considering a sentence and left everything for evidential adjustment by the initial court. And the fact that would constitute some kind of duplication of sentencing, what we normally call double jeopardy. But I'm looking forward to see whether it will be of their interest and under what circumstances they will then have to take over the responsibility of the initial judge under this circumstance.
What does the law permit in terms of the separation of powers, if you will, between the courts?
The provision is very clear that the judge who heard the matter should finally give sentence. But of interest, I think it was more of state having considered the fact that there's a minimum sentence and the judge could have not applied her mind properly by not considering minimum sentence. The fact that it is a minimum, it's murder. But the kind of murder that has been adjusted in the evidence is clearly such murder that it will warrant consideration of minimum sentence. But the court also have powers to look into aspects that can also not go for the maximum or minimum, can go for any other lesser sentence. In this case, Judge Masipa considered that.
Yeah, but I mean, is the NPA then, in your view, in a sense, questioning the discretion of Judge Thokozile Masipa?
Of course, that's the reason for they approach the Supreme Court of Appeal. If they weren't considering that, they wouldn't have make efforts in that respect.
Yeah.
They would have appreciated the fact that there's been sentencing and then there's been retributive consideration and preventative consideration. Because one of the reasons why a person has been convicted and found guilty is the fact that subsequently the judge will have to take consideration of factors for this person to serve sentence according to what has been accused. And in these instances, NPA has gone further and further to make sure that they stick to the principle of minimum sentencing, which is 15 years for murder. And then the Supreme Court will have to make that determination. But key in this respect is, are they in best place position to adjust what have been determined as evidence in the initial case? Something that I have a serious doubt about.
I mean, it's obviously, as you're saying, it's not fair play, or it's a complicated case. Which way is the Supreme Court of Appeal legally bound to rule on?
Look, currently the constitution of this country makes provision for any form of applications and value system that should enshrine their decision. And if in this case, it's going to be one of the cases that the rule of law will include, among others, double sentencing, it will be interesting to look up to. Because for me, this is one case of double jeopardy, as initially alluded to, because sentence has been served, has already been in jail, and for them just to change for the sake of compliance with the books, it's very interesting and looking forward for it.
But what implications would that then have should the SCA encroach, their decision, for example, of an extension of the sentencing?
Look, that decision will be binding for a period of time, and it depends on whether the legal team of Oscar will then follow up another avenues that might find themselves in there. And under circumstances, it's difficult for one to speculate whether indeed they will have further considerations. Because 6 years currently served, and if court says it's enough, he has served his due, he's going to be considered for rehabilitative sentencing, or the intention is to prevent. And under the case, when you prevent a person from furthering a particular criminal act, I think there is more important things to look into than simply to say because he's committed murder and therefore should not be considered for other factors that will then mitigate the sentencing consent. And I'm looking forward to see whether they're going to articulate the mitigation, the aggravating circumstances in the same manner that they'll have articulated it before Judge Masipa.
Okay. Well, it's something that we'll be watching very closely, Rengake. Thanks so much. As always, that's Advocate Mailengake, Transform RSA lawyer. And we had on the phone line Mr. Siabulela Gentile, not in my name, SA Chief Executive Officer and co-founder. And thanks indeed for you at home for taking the trouble to call in. We'll take a break and we'll see you shortly.